Welcome to the deep dive. Today we're tackling U.S. employment law. It's a dense area, right?
Definitely. There's a huge amount of information out there about workplace rights,
Mm.
employer duties. It can feel overwhelming.
Yeah, exactly. So think of this as us grabbing that big legal guide and pulling out the really crucial stuff for you, the interesting bits.
Our mission, if you will,
Yeah,
is to make sense of it without getting bogged down in legalese.
precisely. We're focusing on three big ones today: the Fair Labor Standards Act, or FLSA,
Then the Employee Polygraph Protection Act, EPPA.
and finally the National Labor Relations Act, the NLRA. These really are foundational laws.
They cover the core of the employment relationship: pay, hours, specific practices like lie detectors, and collective action.
Right. So the FLSA handles the basics, the fairness around pay and work time. EPA deals with, well, lie detectors, pretty specific.
And often controversial.
Yes. And the NLRA is all about employees having a collective voice, organizing, bargaining.
Our goal is to give you a clear, practical view. Maybe uncover some surprising details along the way. Things relevant whether you're, an employer or an employee.
Okay, let's jump in. The big one first. The Fair Labor Standards Act, FLSA.
Right. The FLSA. Its coverage is, well, it's broad. Very broad.
It applies to most businesses, doesn't it? Public and private sector.
Pretty much any organization engaged in commerce. That includes places like public hospitals, schools, things you might not immediately connect with typical business.
And a key thing here is figuring out who actually counts as an employee under the law. It's not always obvious.
Exactly. It's not just about what your contract says. The law uses what's called the economic reality test.
Ah, yeah, the economic reality test. So it looks past the job title.
Totally. It tries to figure out the real nature of the working relationship. There are 6 main factors they look at.
Okay, what are they?
Well, first, the employer's right to control how the work is done.
Mm-hmm.
Then the employee's opportunity for profit or loss, like, can they make more by working efficiently?
Makes sense.
Also, the employee's investment in equipment or materials. Does the worker bring their own tools, for instance?
Okay.
Fourth, whether the job requires special skills. Fifth is the permanence of the relationship. Is it ongoing or just a one-off project?
And the last one?
How integral the worker's services are to the employer's actual business. Is their work a core part of what the company does?
So using that test, someone you think is an independent contractor might actually be considered an employee by the law. That's a huge point for employers to grasp.
Absolutely. And it also means some are clearly not covered. Genuine independent contractors, for example.
Right, people truly in business for themselves.
And interestingly, prisoners are generally excluded too, though that's more from court decisions than the text of the Act itself.
Okay, so we know who's generally covered, but what does the FLSA not mandate? Because there are some surprising gaps.
Oh, definitely. It doesn't require employers to give you paid vacation time or paid holidays or severance pay if you lose your job.
No mandated sick pay either, right?
Correct. No federal requirement for sick pay. It also doesn't force employers to provide meal breaks or rest breaks, though some states do.
And no extra pay just for working weekends or holidays?
Nope. And maybe most surprisingly, for workers 16 and over, there's no limit in the FLSA on the number of hours you could be required to work in a day or a week.
Wow, so it really focuses on the minimum standards.
Exactly. The floor, not the ceiling. Its main focus regarding pay is the federal minimum wage, of course.
And overtime, that's the other big piece.
Yes, time and a half pay for hours worked over 40 in a work week.
And calculating that isn't always straightforward, is it? Especially if you're salaried?
No, you have to figure out the employee's regular rate of pay first. That involves looking at total weekly compensation, backing out certain things like some bonuses or premium payments already made.
Right, you don't just multiply the base hourly rate by 1.5 necessarily.
Correct. You need the regular rate for that week.
Mm-hmm.
But then, and this is crucial, not everyone who works over 40 hours is entitled to overtime.
Ah, the exemptions. This is where it gets complicated.
Very. There are specific jobs listed, like seasonal amusement park workers, babysitters on a casual basis, some newspaper deliverers.
And some journalists too, I think.
Yes, certain types, depending on their duties. But the main ones most people encounter are the so-called white-collar exemptions.
Right, the ones updated back in 2004, executive, administrative.
Professional, computer employees, and outside sales. Those are the big 5.
And defining these isn't always easy. I know there have been court cases, like Pharmaceutical sales reps, they're generally exempt.
Typically, yes, under outside sales. They spend their time on the road, promoting products, making sales.
But what about, say, service advisors at a car dealership? I remember a case about them.
Right, the Supreme Court weighed in on that. Generally, they are not exempt. Even though they interact with customers and recommend services, their primary duty wasn't seen as fitting the administrative or sales exemptions in that context.
So titles don't mean much. It's about the actual job duties.
Exactly. And there's a formal test to determine exemption status. It has 3 parts.
Okay, what's the test?
First, a salary limit test. You generally have to earn above a certain amount per year to even potentially qualify. There are specific thresholds.
Okay, minimum salary. What else?
Second, the salary basis test. This means you have to be paid a predetermined fixed salary that doesn't change based on the hours you work or the quality of your work each week. There are some exceptions, but that's the general rule.
Got it. Fixed salary. And the third part?
That's the duties test. And this is often the trickiest part. The employee's primary duties must involve the kind of work associated with that specific exemption category.
Like executive decision-making or exercising discretion and independent judgment for administrative roles.
Precisely. Or advanced knowledge for professionals, specific high-level tasks for computer employees, or making sales outside the office for outside sales. If your main tasks don't fit, you're likely non-exempt and owed overtime, even if you meet the salary tests.
So salary plus the right kind of duties. Okay. Now, related to hours, what actually counts as work time that needs to be paid? Compensable hours.
Right. Compensable hours include all the time you're actually performing your main job duties, plus any other time spent on activities that are integral and indispensable to those duties.
But there are some gray areas or maybe surprising exclusions, like security screenings.
Yeah, that's a big one, the Supreme Court clarified. Time spent waiting for and undergoing security checks, like bag checks at the end of the day, is generally not compensable time under the FLSA.
Even if it takes a while.
Even if it takes a while, it's considered outside the core work activities.
Okay. What about the time just before you officially start or just after you finish your main tasks, like walking to your station or putting on gear?
That brings us to the Portal to Portal Act. It amended the FLSA. Basically, it says that preliminary activities, things you do before your principal activities start, and postliminary activities, things after they end, are generally not compensable.
Like waiting around.
Exactly. Waiting to be told what to do isn't usually work time. But there's a key development here regarding protective gear.
Ah, right. If you have to wear special safety gear.
Yes. A 2110 regulation states that time spent donning, putting on and doffing, taking off, required protective gear is generally compensable work time.
So putting on the hard hat, safety glasses, steel-toed boots, that time counts?
Usually, yes. And it gets even more specific. Courts have looked at the time spent walking between, say, the locker room where you put on the gear and your actual workstation.
And that walking time can count too.
It often does, yes. It's considered part of the continuous workday once you started those principal activities, which can include required donning. We even see expert witnesses in class action suits testifying about how long these things take on average.
But I bet there's a but.
There is. If there's a collective bargaining agreement, a union contract that specifically says time spent donning and doffing this gear is not paid time, that contract can actually override the general rule.
Interesting. So union contracts can modify these FLSA requirements sometimes. What about lunch breaks?
The FLSA doesn't require them. But if an employer provides them, meal periods longer than 30 minutes where the employee is completely relieved of duty are generally not considered work time. Shorter breaks usually are.
Okay. But there's a specific protection now for nursing mothers, right, under the ACA?
Yes, a very important one. The Patient Protection and Affordable Care Act amended the FLSA to require employers to provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth.
And they need to provide a private space, too.
Yes, a place other than a bathroom that's shielded from view and free from intrusion. That's a key protection.
Good to know. And just to confirm, commuting time, driving to and from work.
Generally not compensable. That's your own time.
Okay. Let's shift slightly within the FLSA to child labor rules. There are protections for younger workers.
Yes, definitely. The FLSA sets minimum ages for different types of work. Generally, you have to be 16 for most non-farm jobs.
And 18 for anything considered hazardous.
Correct. The Department of Labor maintains a list of hazardous occupations prohibited for minors under 18. Things like operating heavy machinery, roofing, excavation.
Are there any exceptions for younger kids?
A very limited one for 10 and 11-year-olds.
Hmm.
They can do some hand harvesting of certain crops outside of school hours for short seasons, under very strict conditions.
And what about kids working for their parents or child actors?
Yes, there are exceptions there too. Children employed by their parents in non-hazardous jobs in agriculture, for example, and laws governing child actors or newspaper deliverers are often different or fall under state regulation.
Okay, so how are these FLSA rules enforced? Who makes sure employers comply?
The Department of Labor's Wage and Hour Division is the primary enforcement agency. They can conduct investigations, supervise back wage payments.
Can they sue employers?
Yes, the Secretary of Labor can file lawsuits to recover unpaid wages and an equal amount in liquidated damages. They can also seek injunctions to stop violations. And there are civil money penalties, especially for child labor or repeat willful violations.
Can employees sue on their own?
Absolutely. Employees have the right to file private lawsuits to recover back wages, liquidated damages, plus attorney's fees and court costs.
Is there a criminal aspect?
For willful violations, yes. The Department of Justice can bring criminal charges, which could result in fines or even imprisonment for repeat offenders.
And there's a time limit to file these claims.
Yes, a statute of limitations. It's generally 2 years after the violation occurred.
But longer if it was willful.
Right. If the violation was willful, meaning the employer knew or showed reckless disregard for whether their conduct violated the act, the statute of limitations extends to 3 years.
And crucially, there's protection against retaliation, isn't there, if you complain about FLSA issues?
Hugely important. The FLSA forbids employers from firing or discriminating against an employee for filing a complaint or participating in an FLSA proceeding.
Does the complaint have to be formal, like written to the DOL?
No, and this is key. The Supreme Court confirmed in the Kasten case that even oral complaints made to the employer can be protected activity under the anti-retaliation provision.
So just telling your manager you think you're not being paid correctly could be protected.
Exactly. That's a significant protection for employees who want to raise concerns.
All right, that's a lot on the FLSA. Let's move to our second law. The Employee Polygraph Protection Act, EPCA. This one's much narrower in scope.
Much narrower, yes. It deals specifically with lie detectors in the employment context.
And the basic rule is that most private employers can't use them, right?
That's the main thrust of it.
Yeah.
The EPDA generally prevents private sector employers from requiring, requesting, suggesting, or causing any employee or job applicant to take a lie detector test.
So no pre-employment polygraphs for most jobs.
Correct. And they also can't use the results of any lie detector test or fire or discipline someone for refusing to take one.
Does it apply to all employers?
It applies to most private employers engaged in commerce. But there are big exceptions. Okay, what are the major exceptions? Who can use polygraphs?
First and foremost, all levels of government employers, federal, state, and local, are completely exempt. The EPPA does not apply to them.
Okay, so public sector jobs are different. What about private companies? There are specific federal exemptions. National defense and security contractors, for instance. Companies working with agencies like the Department of Defense, Department of Energy on sensitive projects, or intelligence agencies like the CIA or FBI contractors. They might be allowed to test employees or applicants in certain situations related to security clearances or investigations.
Got it. National security are related. Are there any exemptions for regular private businesses?
Yes, a few important ones. The most significant is for ongoing investigations of economic loss or injury to the employer's business, like theft or embezzlement.
But they can't just test everyone if money goes missing, right?
No, absolutely not. It's very restricted. The employer must have a reasonable suspicion that the specific employee being tested was involved in the incident, and there are strict procedural safeguards the employer must follow before, during, and after the test. No random testing allowed under this exemption.
Okay, so specific ongoing investigation with reasonable suspicion. Any others?
Yes. Companies whose primary business is providing armored car services or designing and installing security alarm systems. Basically, security service firms. They can test prospective employees.
Makes sense for security jobs.
And there's an exemption related to controlled substances, allowing testing of current employees by employers authorized to manufacture, distribute, or dispense controlled substances, but again, under specific conditions related to potential theft or diversion.
So quite limited outside of government and security roles. What are the penalties if a private employer violates the EPPA?
The Department of Labor can seek civil penalties up to $10,000 per violation.
And what about the employee who was improperly tested or fired?
They can sue the employer in federal or state court. They can seek legal and equitable relief, which might include employment, reinstatement, promotion, payment of lost wages and benefits.
And attorney's fees.
Yes, reasonable costs and attorney's fees can also be awarded.
Is there a time limit for an employee to sue?
Yes, the statute of limitations for EPA claims is 3 years from the date of the alleged violation.
One more thing on EPA. What if a state has its own law about lie detectors that's even stricter than the federal law?
The EPA does not preempt stricter state or local laws or even provisions in collective bargaining agreements that provide greater protection. So, if a state completely bans polygraphs in employment, that ban stands.
Okay, good to know. Federal law is the floor, not the ceiling there, too. All right, let's tackle our third major act, the National Labor Relations Act, or NLRA.
Right, the NLRA. This one governs labor relations, specifically union organizing and collective bargaining, but only in the private sector.
That's a critical distinction again. This doesn't cover government employees.
Correct. Federal, state, local government workers have different laws governing their labor relations, if any. The NLRA's goal is primarily to protect employees' rights to act together to improve their wages and working conditions, free from employer coercion or interference.
And the core rights are laid out in Section 7 of the Act, right?
Exactly. Section 7 guarantees employees 4 main rights. First, the right to self-organization to form, join, or assist labor unions.
Okay, the union part. What else?
Second, the right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. This is broader than just unions.
Can you give an example of that? What's concerted activity outside a union context?
Sure. Could be 2 or more employees complaining to management about safety issues, or circulating a petition about wages, or even discussing work conditions on social media, potentially. The key is that it's concerted, done together, or on behalf of others, and related to mutual aid or protection regarding terms of employment.
So acting collectively even without a formal union. What's a third right?
The right to bargain collectively through representatives of their own choosing. Basically, if a majority chooses a union, the employer has to bargain with that union.
And the fourth?
The right to refrain from any or all of these activities. Employees generally can't be forced to join or support a union.
Unless
Unless there's a valid union security clause in a collective bargaining agreement, and even then, only in states that do not have right-to-work laws.
Right, the right to work states. There were quite a few of those back in 2018, I recall, around 28.
That sounds about right. In those states, employees can't be required to join a union or pay union fees as a condition of employment, even if there's a union contract.
Okay, so Section 7 gives employees rights. Section 8 is about what employers can't do, the unfair labor practices, or ULPs.
Precisely. Section 8 outlines employer ULPs. 8A is the broadest employers can't interfere with, restrain, or coerce employees in exercising their Section 7 rights. Lots of actions can fall under this.
Like threatening employees if they support a union.
Absolutely. Or promising benefits if they vote against one. Or spying on union activities. Then there's 8A2, which prohibits employers from dominating or illegally assisting a labor organization, like setting up a company-controlled union.
Okay, what's 8A3?
That prohibits discrimination in hiring, firing, or any other term of employment to encourage or discourage membership in a labor organization. You can't fire someone because they're a union organizer, for example.
And 8A4. Sounds like retaliation again.
It is. It protects employees from being fired or discriminated against because they filed ULP charges or gave testimony under the NLRA, similar to the FLSA protection.
And finally, 8A5.
That requires employers to bargain in good faith with the union duly chosen by employees over mandatory subjects like wages, hours, and other terms and conditions of employment. Refusing to bargain is a ULP.
Does the NLRA also list things unions can't do?
Yes. Section 8B details union unfair labor practices. Things like restraining or coercing employees in exercising their rights, causing an employer to discriminate against an employee, refusing to bargain in good faith with the employer, or engaging in illegal secondary boycotts.
And there's something about free speech, too, Section 8C.
Right. Section 8C protects the expression of views or opinions by either side, as long as it doesn't contain a threat of reprisal or force or a promise of benefit. There's a line between permissible persuasion and unlawful threats or promises during organizing campaigns.
Okay. Who enforces all of this? The National Labor Relations Board, the NLRB.
Correct. The NLRB is the independent federal agency responsible for enforcing the NLRA. It has 2 main functions: conducting representation elections and resolving unfair labor practice charges.
So representation cases are about deciding if workers want a union.
Yes. The NLRB determines the appropriate group of employees for a bargaining unit, conducts secret ballot elections to see if a majority wants union representation, and then certifies the results. It also handles petitions to decertify existing unions.
And the unfair labor practice cases, how does that work?
It usually starts when an individual, a union, or an employer files a charge with an NLRB regional office. The NLRB's general counsel investigates.
Does the general counsel have the final say on whether to pursue it?
On issuing a complaint, yes. That decision whether or not to issue a complaint is generally not reviewable by courts. If a complaint is issued, the case goes to a hearing before an administrative law judge, or ALJ.
Like a trial.
Sort of, yes. The ALJ issues a decision, which can then be appealed to the 5-member board itself in Washington, D.C. The board needs a quorum, usually 3 members, to issue decisions.
And can the board's decision be appealed further?
Yes. Parties unhappy with the board's final order can seek review in a U.S. Court of Appeals. And the NLRB can also go to the appeals court to enforce its orders if an employer refuses to comply.
Okay, so there's a whole administrative and judicial process. What about the relationship between the NLRB and state courts? Can you sue over NLRA issues in state court?
Generally, no. This is the concept of preemption again. State courts usually lack jurisdiction over conduct that is arguably protected by Section 7 or prohibited by Section 8 of the NLRA. The idea is to have a uniform federal labor policy.
Are there exceptions?
A few narrow ones. States might still have jurisdiction over matters of peripheral concern to the NLRA, or where the conduct touches interests deeply rooted in local feeling and responsibility. Classic examples are violence, threats of violence, or trespass during a labor dispute.
And there's another type of preemption, too, field preemption.
Yes, sometimes called machinist preemption after a Supreme Court case.
Yeah.
It means that some areas of labor conduct are intended by Congress to be unregulated, left to the free play of economic forces between labor and management. States can't regulate in these areas either.
What about when a union contract, a collective bargaining agreement, or CBA already exists? How does that interact with state law? Section 301.
Right. Section 301 of the Labor Management Relations Act, which amended the NLRA, deals with suits for violation of CBAs. It generally provides that such suits are governed by federal law.
So if a state law claim requires interpreting the CBA, it's likely preempted.
Exactly. The key test from cases like Lingle is whether resolving the state law claim requires interpretation of the collective bargaining agreement. If it does, federal law governs, and the claim might have to go through the grievance arbitration process defined in the CBA first.
But who decides if the CBA was even properly agreed to in the first place?
According to the Granite Rock case, courts, not arbitrators, generally decide questions about the formation or ratification of a CBA. And that same case clarified that Section 301 mainly creates federal jurisdiction for breach of contract claims, not necessarily other types of disputes between employers and unions.
Okay, wow. We have covered a lot of ground today. FLSA, EPPA, NLRA, quite the deep dive.
It really is. We went from the basics of wages and hours under the FLSA.
Yeah, with those interesting bits about compensable time security screenings, maybe not, but donning protective gear, often yes, and those breaks for nursing mothers, definitely.
Right. And the very specific rules around lie detectors in the EPA, remembering that huge public sector exemption.
And the NLRA's framework for private sector collective action, that whole idea of protected, concerted activity being broader than just formal unions.
Absolutely. And the details matter. Like knowing an oral complaint can be protected under FLSA's anti-retaliation rules, or understanding the limits on polygraphs in private investigations.
It really gives you a foundational understanding, doesn't it? Whether you're an employee figuring out your rights or an employer trying to navigate compliance.
Hopefully, yes. A clearer picture of these critical laws.
So, to leave our listeners with something to think about, considering everything we discussed, especially that economic reality test under the FLSA for who's an employee versus an independent contractor, where do you see that line getting the blurriest today? With remote work, the gig economy booming, what kind of work arrangements really test that definition?
That's a great question. It's definitely a hot topic legally.
Something to ponder as the workplace keeps changing. As always, we encourage you to dig deeper if something sparked your interest, and feel free to send us questions for future explorations.